There we go. Right, guys, so today we're going to have hopefully a bit of fun, and we're going to be a bit relaxed because what we're doing this weekend is basically looking at children. And the main thing with looking at the law around children is understanding what the main concepts are and the job that it is the law is trying to do, because your law is very interesting in that it's a mixture of English and Scottish law, which is intriguing. But what all of those jurisdictions have tried to do is to have one law, which is a one-stop shop. So it deals with every aspect of children's stuff, which is great. But the main thing is to understand what it is the law is trying to achieve, and then you can learn the technicalities around it. We're going to start, though, by looking at domestic violence and domestic abuse. Now, I'm a bit intrigued because the law in Guernsey around this is quite developed. Is that because you have a lot of it in your experience? Yeah.
Oh, yeah.
A lot. Because you've even got a strategy. The states of Guernsey have even got a domestic abuse strategy for the next, well, it was done in 2016. So a 4-year strategy plan for domestic violence. And that would suggest that they think there's an issue on the island.
I think we do have very high stats.
Okay. For your population, perhaps.
Both men and women.
Yeah. People tend to think it's mostly a problem inflicted by men on women.
Yeah.
The statistics would say that's correct, that most domestic violence is by men on women, but that is quite possibly because domestic violence inflicted on men is underreported. So it's very difficult to know, actually, where the truth of it lies, because the truth is that men don't report it, they're too embarrassed or whatever.
And if they don't report it, you have no way.
You've no way of measuring it. It's an unmeasurable. What we can say is that a significant number of women in the UK, and there are UK statistics on it, suffer abuse in their relationships, which is very sad. It's also a very difficult thing to define, and that's something that we'll have a bit of a look at in terms of the law. Why is it important? Well, the reason it's important for you guys to study is because it's very common, but also because we've come to realise over the last, I would say, 20 years or so, that domestic violence and domestic abuse are really, really important to, in particular, children. It wasn't until relatively recent, and that is the recent past, I guess, that it really occurred to us that children who are not directly the victims of domestic violence suffer as a result of it. What we know now is that if children are living with domestic abuse and domestic violence, it has a really profound effect on their development as humans. It affects all kinds of issues. It affects their ability to form attachments, because in fact they don't really trust the adults around them, because they're experiencing a very frightening situation and atmosphere, and they are powerless. They can't do anything to escape it, and nor can they protect the person, the adult who is a victim of it. They're also learning that this is how relationships work. So people who perpetrate domestic abuse and domestic violence will often have lived in households as children where that was present, because for them this is normal life. Yeah, it's a learned sort of pattern of behaviour, but if you learn that pattern of behaviour as a young child, it is very difficult to break it, because it becomes part of your norm, your sense of what is normal. So it's very important because we know it ruins children's lives. And actually, we used to think that it was older kids that were affected, so the ones who could see, hear it, teenagers, whatever. We now know that arguably the most heavily impacted are babies, are young children who hear it going on in the house. It's also really tricky as a practitioner, and perhaps as a human being, because relationships where there is domestic abuse and domestic violence are really complicated relationships. So you tend to feel it as a practitioner before you know the facts of what is happening. And one of the big challenges in family law is seeing this as a problem, is knowing that there's something going on in this case that isn't quite right. Because very often your client ain't going to tell you. If they're a man who is an abusive partner, they are not going to tell you that. And quite often, if it's a woman who's experiencing abuse, they won't tell you either. Sometimes because they're scared, but very often because they don't think there's anything wrong with it. They think it is normal. And women will bounce from domestic abuse relationship to domestic abuse relationship to domestic abuse relationship, because for them it is what relationships are like. So you may have to spot hazards that your client can't even see. And that's evident in some of the examples, the activities I've given you, which again are things that have really happened to me as a practitioner, where women will say, oh, you know, he's done this, he's done that, he's done the other. And they'll tell you in almost a deadpan way, some really quite awful stuff, because to them it's nothing spectacular. They normalise what they experience because that's what humans do. And then they'll say, oh, and he's coming around to see the kids later, and but I'm sure it'll be fine. You know, if he shouts a bit, they're used to that, it's okay. He's never actually hit anybody. It's quite a common one. I've had one case where it might have been a public law case, I might have been acting for the state actually, where mum was putting the child to bed in her bed whenever her husband was drunk, because that way he wouldn't rape her. And all he would do, and I've come across it more than once in different cases, and he would just move the child. But these are families who are quite often living in one room. Certainly in Jersey, but I don't know how your accommodation dynamic is, but people are quite often living in very small bits of accommodation and sharing it. So it's seeing it happen or sensing it's happening because your client may not tell you, and knowing what to do when you see it. Because you may have a client who is saying to you, I'm going to tell you these things, but I want it to stay secret. That's a real problem. And that happens from time to time with sexual abuse in particular, or abuse of a child. You know, it won't help us if he goes to prison, whatever. I can't do anything about this. I don't want you to tell the judge. It's not an uncommon one. The courts need to know domestic abuse is happening when it's happening, which is partly why they rely on you guys to spot it. And Guernsey is brilliant in that you've got this amazing practice direction, similar to what they've got in England. It's not identical actually, but it's similar, which says, look guys, in cases where you've got domestic violence or domestic abuse, this is what you need to do, because as a court we've got to manage this. So A, we need to know it's happening, you've got to tell us, or that there's a worry about it. And B, these are the things you should be thinking about. Do you need some interim orders? What do you need to make this happen safely? The reason it's a real issue for family court judges, and therefore for you guys, because they rely on you, is because where there is abuse and violence, it seeps into every area of a family case. It affects the money, because you are more likely to have one party in control of all the assets. You're probably more likely to have a party hiding assets. You're probably going to have someone throwing their weight around, so you will have an unequal position and a bit of bullying going on. And that is a very difficult dynamic to manage as a lawyer, in trying to do a deal that's fair. And as a judge, if you have to sign off on a deal saying you believe it to be reasonably fair. So it's something that everybody needs to be really careful about, even with money. And with children, it's a nightmare, because the court has to decide, is there domestic violence here? Should these kids have a relationship with this abuser? And if so, is it safe? And even better than that, there are abusers out there, and not a small number of them, who pursue orders in relation to kids as a way of getting to the other party. They will pursue orders to victimise the mother generally, but sometimes the father. And the children are literally weaponised. Now that is very, very difficult for the court to manage, because as we'll explore, The general principle is that children should have a good relationship with both parents. They should spend time with both of them. But that is really tricky where you've got this dynamic in there. So there are things the court needs to know from you guys, and you've got brilliant practice directions which tell you step by step what the court needs you to do. Excellent. We can have that in Jersey. Brilliant. Brilliant stuff.
It's easy to find, isn't it?
Yes. It's I've identified it in here, but I think what I will do, I'll probably stick it on the website actually.
There were 2.
It's practice direction 6 and practice direction 5. Practice direction 6 is the long one, I think. Court must at all stages of proceedings consider whether domestic abuse has been raised as an issue. Because the court may often have to decide whether something happened or not. Because normally there's an argument. So the court may have to think about whether it's going to have what we call a fact-find hearing, which is a lot like a criminal case, where a judge will decide on a balance of probabilities whether something happened or not. But in order to make that decision, and to do it quickly, because delay is a bad thing when it comes to kids, we need to know that domestic abuse is happening.
Can I just ask you, the Hampton Trust earlier, you said it's not.
I think it was the Hampton Trust. I'll have to check Cherry's email, but she said there was one of these which is no longer around and has been replaced with something else. Don't worry about it. I will send you an email. But it's been, it's to do with the old service required a conviction. And we have a similar thing in Jersey called the ADAPT course, which is run by probation, where men who have a conviction for an incident of domestic abuse can undergo a programme to try to reform them, for want of a better term.
The SANIA programme.
I think that's
replaced the Hampton Trust, because that's only for men.
Okay. Yeah. Okay.
But in order to get into it, you have to acknowledge.
You have to acknowledge there's an error. Yeah.
It's a
SANIA programme.
And is it counted?
Yeah.
I think it's just a bit more extensive and a bit better, was sort of what Cherry was suggesting.
I think it when there was a local doctor involved in improving it.
Yeah, and it is important because it's quite easy to demonise men who are the perpetrators of domestic violence. And the reality is that it's often a lot sadder than that. These are people who, for whatever reason, behave in this way for a fashion. The best thing for everybody is that they learn to behave in a different way, rather than just demonising them for the fact that it's a problem. And there are degrees of domestic violence, and that's partly what makes it really difficult as a practitioner, is identifying how much of a risk there is. Because your client's not going to tell you everything. It will come out in a drip. So your client might say to you at the first meeting, he gets a bit angry sometimes. Then she'll happen to mention to you a month later, oh, I told you, didn't I, about that time you hit me? No. And then she'll say a couple of weeks later, oh, and I told you about that thing that happened with the kids. And it comes out in a sort of drip like that. So part of the skill is understanding at an early stage there's something there, or just getting a feeling and being able to gently prise it out of your client. Because part of the reason they won't tell you is because they don't think there's anything odd about it. They think it's normal. Sometimes they're embarrassed. Sometimes they blame themselves. A lot of the time they will think it's their fault because they wind him up. And quite often they've been threatened in some way. A very, very common one is, if you have a go at me, I'll tell them you're mad. And it is not uncommon for victims of domestic abuse and violence to have mental health problems and to have vulnerabilities, often before the relationship has started. So if you have the father of your child saying to you, I'll tell them you're mad, I'll take your children away, you'll never see them. Oh, and they'll come and stay with me. I had one that was a direct threat. He's told me that if I divorce him, he'll get contact with the kids and they'll stay overnight with him. And she was so scared of that man being left alone with her children, she'd stayed with him for years. Because otherwise he would have had contact on his own. But they won't tell you this stuff until they know you, because they don't trust you. So it's prizing that information out of it. One of the other evidential problems is there won't be any evidence. So proving it is very tricky, because occasionally, if you're lucky, they've been to a doctor.
Then just goes down to just your client giving the evidence.
Yeah, it's one person's word against another, and occasionally family members share bruises, whatever. And emotional violence, and a lot of this is about coercive control, is very, very difficult to prove because there are no bruises. So you look for things like all the bank accounts being in one name, the houses being in one name, husbands having control over phone bills, so they get to itemise phone bills for who their wife is ringing, all of those kind of things, but it's all quite subtle. And you have to assess when you see a client how much risk they are in, because they will not see it for themselves. They never do, domestic violence victims. So you may well have a client who's sitting in front of you saying, I want to get divorced, I've had enough now. Still living under the same roof as their abusive partner, and having to think with them about how much danger they are in the second they have that conversation. The second the question comes up of who's leaving the house, because he won't leave, or she won't leave if she's the abuser, how safe they are, and even after they're physically separated, if you issue a divorce petition on a behaviour basis, which you quite often do with domestic violence, it's a very common pleading, is to have as your fact some form of domestic violence amounting to behaviour. How's he going to react when that falls through his letterbox? How are you going to manage that? How are you going to stay safe? And those are things that you have to think about, because your client won't. They just won't cross their heads to think about these things. And that's why it's dangerous, because people can and do die. We've had a number of domestic murders in Jersey. I don't know how often you get them in Guernsey. Yeah. We had one a few years ago, probably about 4 years ago now, where a man whose wife had had an affair went basically ballistic and killed 6 members of the family. The wife, both children, her best friend, and her father.
I remember that one. Was it
Polish family. And yeah, her best friend and her best friend's daughter. So he killed 3 children under 5, and we've had a few other domestic deaths as well. So it's something that you really can't afford to get wrong. And a lot of it is around the home, which is why the law around this area tends to focus on how can we give someone control of the home, because that should be a safe space. And if you can control the home, even on a short-term basis, and combine that with other orders, non-molestation orders, which any human can get if someone's being abusive towards them, how can we combine that package to try to keep families safe, particularly where there are children? And that is what the law is trying to do. But at the same time, we have to respect the human rights of abusers.
Do you think that case could have been avoided? Because it sounds as though he was intent.
The truth is, you never know. You never know if I have no reason to think that lawyers were even involved in that case at any stage. But I know from
For short of arresting him or keeping him.
It's very difficult, isn't it? Had they not all been living in the same house, would it have happened? I don't know. If someone had identified it as a problem, would it have happened? If the house had been under watch by the police, would it have happened? I don't know. And in the end, he was acquitted of murder in Jersey.
How?
It was a curious case. He was acquitted of murder, went down for manslaughter, I think on the basis of diminished responsibility. Although actually, if you looked at the pattern in which he murdered people, that was a surprising verdict for me. And he then killed himself in prison very shortly afterwards. So, tragic cases. I had a colleague, or have a colleague, who does not touch family law anymore because he was getting to the last stages of a divorce, very, very difficult case, but thought everything was fine. They were nearly there, and he killed his wife and 2 children and put them into his car. And that those kind of things are some of the pressures that family lawyers really are dealing with, because particularly if you're working in the field of children law, the risks are massive sometimes. The risks, if you get it wrong, it's not just about the money. If children are abducted, hurt or whatever. So one of the things is to be alive to those risks as a practitioner, because you're the first aider, if you like. You're the first responder. Quite often, you'll be the first to actually see and hear this stuff. And if the judge doesn't know, the judge can't help. So that's why domestic violence law is important. And it's also why it's still evolving. And we'll have a look at how that's happening now, because it's only, as I say, relatively recently that we started to get a grip on how important it is to actually understand this stuff. So actually getting a definition of domestic abuse and domestic violence is a bit tricky, because there is no such thing as an offence of domestic violence. Okay, and this area of law in family ties in a little bit with criminal law, because quite often the police would have had a look at things as well. They may or may not have charged someone. Quite often they won't. For example, like Josie, we tend not to have that many domestic violence prosecutions, unfortunately. But in England, for example, we're now getting the offence of coercive control is now a criminal offence in England, which is psychological violence. So the criminal law is developing, certainly in the UK. I suspect it's certainly less so in Jersey. I don't know what the state of it is in Guernsey. But you may have to be aware when you're working on a case where you suspect some domestic violence or domestic abuse, the police may become a presence at some point. And you may have to think about, from an ethical point of view, what you are going to do if someone sitting in front of you gives you cause to think that someone is at risk of violence. Whether it's particularly a child, but not exclusively a child. If someone says to you, I know I'm going to go home and he's going to beat up little Johnny because little Johnny sticks up for him, you're going to need to think about what your professional obligations are in those circumstances, in case it all goes horribly wrong. The only clients I have who have my private mobile number are clients with domestic violence issues.
Or email.
So, Claire, what would you do if you are, well, what do you do when you're faced with a client who says, look, I want you to keep this up?
I say no.
Okay.
I have been sacked because of it.
Okay.
But that's a rule for me.
How do you gauge the sort of degree of potential harm and when you need to do something?
Do you know what? It's partly experience. I think I always err on the side of caution.
Can you give me an example of when you wouldn't? When you think this is actually not sufficient for me to feel the need to do something, as opposed to just stepping over that?
You know, I think there are some key questions that I ask clients, because the reality is that during a divorce or a separation, whether they're married or not, people are angry, people are upset, and people behave like idiots. There is quite often a little bit of pushy-pulley violence in there, quite often two-sided, but there is quite often an element of physicality about it. It's never happened before. It's effectively a visible one-off, but husband found out wife was having an affair and slapped her. It's a classic example of that, and not there. And the same vice versa. So wife found out about husband's affair, slapped him. Throws wine over him is also a classic. There's wine. Has to be wine, but apparently it doesn't. It's normally red, yeah. It's normally red. Or they cut up clothes. Or I had one where the wife, the husband had a prize car. So she drove it halfway up the garage and then shut the garage door repeatedly. About 6 times. And we got disclosure of his insurance form, the repairs, and one of the questions the insurer had on the claim form was, what are you going to do to avoid incidents like this occurring in future? And it just put divorced wife. So there are incidents where people behave badly. We do not see people out there. They're always in a crisis. If I get the impression that my client is not telling me something, and you get a feeling for that, if you're having a conversation with another human and you think there's something going on here you're not telling me, you sort of dig down a little bit into what it is, what's your relationship like, what goes on at home, what happens when you have an argument is a classic question. What happens when you fall out? How are the kids? Because quite often you'll get kids bedwetting, soiling at school is a classic. Those kind of things. Bad behaviour at school is a classic marker for problems. So you'll just ask a number of questions that will help you identify if there's an issue in the family. And then when they start to talk about how he's very angry, or what does angry look like? Is it shouting? Is it screaming? Is it all the time? Is it swearing? Swearing's a particular trigger where you have someone who's been repeatedly abusive, and they're not quite in control of what they're saying. Text messaging. Are you getting lots of messages from them? In a lot of cases, you get people who, you get repetitive messages, hundreds a day sometimes, very abusive. I'm going to kill you, you fucking cunt. I'm going to tell the kid you're this. I've taught him to call you bitch. Is that all right, cunt? Are you sucking off your bus today? Are your boss today, bitch? All those kind of things are not uncommon. But when it becomes repetitive, then that starts to drift into harassment and abuse, and the police may need to get involved. Yeah, but people say that all the time as well. You do that, I'll kill you. It's not an uncommon turn of phrase, actually. And you get it from, in particular, parents of divorcing couples. Oh, I'll kill him if he doesn't stop it. Please never say that again. Is a classic one. So people say things they don't mean. I'm going to eat you in a minute. And you have to gauge how serious a problem it is. And quite often it comes down to asking them if they are scared. Are you scared? Another classic one is parents will say, if they're feeling intimidated, I think you might grab the children and leave the country. Happens a lot in Jersey. That worry is there. Very rarely happens as a reality, but the worry is there. I think he'll just flip. He'll run off back to Portugal or England or whatever, where he's from. And again, it's gauging out, well, let's look at whether that's a serious risk or not. And judges will say the same thing. Only they can.
Some people can be so devious, acting almost as though everything is normal.
They can, but they tend not to act in a way that is completely illogical. If they've got good jobs here, and their finances are here, and they've got family connections here, and actually you know exactly where their family are in England anyway, how realistic is it? Are you really afraid that they're going to go? Or is this just something in the back of your head that's a bit of a nagging worry? And there is a difference. Sometimes they make threats to go, in which case you have to take it seriously. So it is picking your way through a bit of a minefield, if that makes sense. And quite often they won't identify what they're experiencing as domestic violence or domestic abuse, which is why governments across the world are now trying to publish definitions of domestic abuse so that people understand what we mean by that. Because a lot of people don't realise that what they're experiencing is abusive. So you have a definition of it, not in a family context, you won't find it in the matrimonial causes law, although it probably didn't believe in domestic violence when that was written. Probably encouraged it back then, who knows. And you won't find it in the children law either, even though it's very important to children. You will find a definition of domestic violence, or I think it's physical violence, is within your practice direction. But that is different to Guernsey has a central states definition of what domestic abuse is, which is they've basically taken on the UK definition, which is fine. Any incident or pattern of incidents of controlling, coercive or threatening behaviour, violence or abuse only applies to people 16 or over, because below that, that's child abuse, who have been intimate partners or family members regardless of gender or sexuality, one of the big problem areas that's growing in the UK at the moment is abuse of elders, abuse of pensioners and older family members, not just intimate partners against each other. It can encompass, but is not limited to, psychological abuse, physical abuse, sexual abuse, financial abuse, and emotional abuse. It's a little bit unfortunate, I think, and this isn't a Guernsey thing because this is basically the UK definition. Are many people going to understand the language that's in that? Many ordinary people.
Not somebody off the street.
No. And it's a shame because it's the people off the street it's actually there to protect. Instead, it's used as an understanding base for professionals, which is fine. It's great, but it doesn't necessarily broaden the public perception of domestic abuse and domestic violence, because the number of times you will have a male client, classically, and he will have hit his partner, or he will have behaved in a very controlling way, an emotionally abusive way, and they will sit and say to you, that is not domestic violence, that is not domestic abuse. Shouting, swearing is not domestic abuse. I only gave her a slap, that is not violence. I've got one at the moment, which is a public law case where the dad went down for grave and criminal assault, actually, but he punched the mother, caused her quite serious injuries to her mouth. And he said no, because it was a one-off, which, well, probably wasn't. He's only gone down for it once. Because it was a one-off, it wasn't domestic violence. So they justify it to themselves and adopt the definition they want. It would be nice to have a definition that's a bit more user-friendly. But yes, a family lawyer will see all of those things. Psychological, physical is the obvious one, but actually it's probably almost less common than a lot of the others. Psychological abuse, bullying, belittling, financial abuse, depriving people of money. Very common, and a real problem when you're trying to sort out finances in a family case. Because what they will inevitably say is, well, she's just no good with money. And do you know what? The woman will believe it. She says, right, I'm no good with numbers. And you try getting those women to fill in leftover needs, and they don't have a clue. They do not have a clue about money because they've been so controlled, they have convinced themselves they are incapable of dealing with money. So they don't have a clue what life costs or where money comes from. So really tricky stuff. Sexual abuse, they quite often don't talk about that for a while, but marital rape is quite a common feature of domestic violence. I don't know about you guys, but it's only relatively recently in Jersey that that's really been an offence of rape. In fact, in the UK, I think it was only in the 1990s that they made it an offence. Before then, women were up for grabs once they were married. Would be a certain point of view. Emotional covers all kinds of things, and it's very difficult to prove.
Because the psychological bullying and emotional.
Psychological is slightly different, I suppose, and emotional can take many forms. We'll talk in a moment about something called parental alienation, which is a form of psychological abuse of children, but which also affects one of the parents, where one parent creates a world, in a way, which alienates the children from the other parent. So which causes the children to build up a barrier between them and the other parent. So it makes the kids hate the other parent for whatever reason, to reject them. That creates something called parental alienation syndrome, which is a psychological syndrome which some psychologists believe in and some don't. But the reality is that it is the reason why some dads will never see their child again, which is terribly sad. I think that's a form of emotional abuse.
Not psychological.
Or psychological abuse, depends what level it's at, probably. Yeah. Psychological abuse, you're probably looking for something that causes psychological harm. And you can actually, some people can suffer quite a lot of emotional abuse before they are psychologically harmed. Emotional abuse, quite often the abuser will have cut off, subtly or otherwise, all of their connections with family and friends. So they are isolated. They will have been told they're stupid. That's a very common one. You're stupid. You're mental. You're a bad parent. It's a classic one. You're crap with money. You could never do it by yourself. You're useless. You're fat is a great one. That's very popular. And you're ugly. You don't pay enough attention to your appearance. Those kind of things. So you know.
Do you find it that sometimes there's obviously something that brings the client to come and see you, but when they tell you the baby, you can clearly see that it's an abusive environment, but they just don't understand that.
Yeah.
And then how would you deal with it? Because if they're effectively not believing you, it's not like you could go and get
well, I quite often signpost them to, in Jersey it would be the Women's Refuge or the counsellor. But I'm actually quite frank with them in the sense that I will sit there and say, okay, so this happens and that happens. That is not okay. You may think it is normal for you, but it is not okay. You should not be made to feel that way, or these things should not be happening. Or I'll ask them what they think the impact is on their kids. And that's sometimes when it starts to dawn on them. When you ask them, well, when this happens, how does that affect your children? And that's actually when they start to think about it quite often. Because they do tend to see that the behaviour around their children isn't right. And quite often the children start to emulate the abuse. So they'll start to be abusive to their mother. They'll be very rude, dismissive, they'll swear at her, sometimes even be physically violent towards their mum because they've learnt it's okay. But yeah, it is tricky, and there are people who will say, well, there's nothing wrong with a bit of shouting. You know, nothing wrong with this, nothing wrong with that. The kids aren't there when it happens. They're upstairs asleep. No, they won't be. Parents always, and every parent going through a divorce thinks there is some kind of force field around their chaos of a relationship, which means that their children don't see or hear anything. And I don't know why it is that they think that this cloak of invisibility suddenly descends on them when they're having marital problems. So quite often you have to be frank with them and say that your child knows exactly what's happening. Because they are short and chronologically challenged does not mean they are stupid, and they see and hear everything. Including phone calls. Number of parents who will say, "Oh, I never talk down the other one. I'm really careful about that." But of course, the child is listening to every phone call they have with their friends, their dad, their whatever. So people have to just stop and think and be a bit more mindful about the effects of their behaviour. But it certainly isn't easy. So once you've identified you've got a problem, what can you do? Well, there are ways the law can help you and applications you can make. And there is the softer stuff. And the softer stuff is quite often signposting your client to someone who can offer them support. It might be the police. So you are going to have to think about, because you as a lawyer, there is actually very little we as lawyers can do to keep people physically safe if someone out there is determined to hurt them. We can try and use the legal tools we have to get them control of their home. But if he is going to turn up with a hatchet at 2 o'clock in the morning, you are not going to be able to help him. So there is that kind of, has to be a discussion with them about the police, perhaps a discussion by the lawyer with the police to try and help that promote some physical safety there so they understand who to call. There are IDVAs who you have here, we have them in Jersey as well. Independent Domestic Violence Advisory Service. So they provide support for victims of abuse, which can include providing emergency accommodation sometimes, can involve support with putting them in touch with other people. In Jersey, we have a real problem where we've got victims of domestic violence with no housing qualifications, who can't rent property, So all those kind of things, they provide all kinds of levels of support, and they provide support for young people as well. Your service does, and they can help with some legal services. Hampton Trust, I think, has now become Sania, and that's a sort of education program, really. I suspect if it's anything like the one we have in Jersey, an education program to help men understand the impact of what they are doing, to understand it's not okay, and to learn different ways of managing different situations. So in other words, rather than reaching for abusive behaviour, they have another tool that they can use to deal with the situation. There's the police. They, as in Jersey, have a vulnerable persons unit. It's the FPU, but it's a specialist group of officers who deal with domestic abuse, and hopefully have some more training. There is Action for Children to support young people, and the Hub, and you have social workers. If people who are in a dire emergency and who have children may need to just ring Children's Service and ask for help from Children and Family Services. And there is counselling. Counselling is very important for victims of domestic abuse. Certainly, if they go and see the police or an IDFA, they'll conduct almost like a test. It's almost like a psychometric test to work out how at risk they are. So statistically, how likely they are to become a victim of serious domestic violence, how worried everybody should be, and what they call the circle of violence, whatever it's called, circle of abuse, and where they sit in it. So those are the softer skills, and that's great. And they are probably at least as helpful as anything the law can do. Legal remedies, well, what can we do? In Guernsey, it's great you actually have some law, which is lovely. There are things the Royal Court can do, things a magistrate can do. The police may be around, which is fine. In terms of civil remedies, you can get occupation orders, and they are really there to help you get short-term occupation of the home while the court is sorting out the money. You can get domestic violence orders, and you can get harassment orders, all of which can be very useful. They are not a magic pill. They will not stop someone from coming with an act at your client. Although hopefully the police will. Interim occupation orders are under the matrimonial causes law, which is great. It's not dissimilar to England, but be a little bit careful because your law is simpler. In England, they've got their knickers in a bit of a twist by having something called a balance of harm test, which is very, very complicated to apply to family situations. And the way that they've done that is if you've done injunctions in civil cases, or you know anything about injunctions in civil cases, they tend to apply a balance of harm test there, where they look at who's going to be worse off if we do make this order, what impact is that going to have on the respondent, and if we don't make this order, what impact is that going to have on the claimant, who's going to come out worse. And they have to apply that because it's short-term draconian emergency relief. Unfortunately, if you apply that to a family situation where everybody's got competing needs, you can get your knickers tied up quite quickly between actually a situation where it may be the abuser that stays in the home, because actually their housing needs may be better met by staying in the home than the housing needs of the person who's being abused, because they've got a baby and they can get housed by the state. And there is some English law to that effect, which is slightly bizarre, and it makes it very complicated from an academic point of view, because different scenarios, they have different scenarios in England if you are occupying a home by right, including home rights as a spouse. So if you're a spouse, you have home rights. And if one of you's got an entitlement to the property, so you've got a lease or you own it, they have one set of rules. If you are no longer married and the other person's the one with the right to live in the house, they've got a different set of rules. And if neither of you have the right to live in the house, you're squatters or whatever, there's a different set of rules again. And cohabitees are treated differently to people who've been married. So it's all quite complicated in England. The reason I say that is if you do any reading around this and you come across the law in the UK, great. Don't worry if it looks a bit different, because it is a bit different. So don't panic. Your law is a little bit simpler, which I think is a good thing. We don't have them at all in Jersey, which is a bit of a shame. They're only available, because there's a bit of a clue in the title, it's in the matrimonial causes law, which means that this relief is only available to people who are married. Okay. And when there are children. In order to get an interim occupation order, there have to be children, and they have to be living in property that's covered by Article 46. So it has to be something that's within, they have to be living in a house or whatever, flat, whatever, that is under the jurisdiction of the court. Now that can be rented. We know that because the case of Ellendale tells us that. Includes tenancy, including estates of Guernsey tenancy, because that's personal property that the court has jurisdiction over. It's a shows or whatever you want to call it. It's a contract that you have to benefit of. So it's not just owned property, but it has to be under the court's jurisdiction. That makes sense because courts can't interfere with property that's not within their jurisdiction. Now, in Jersey, certainly, we still have to get ouster orders. Okay. And ouster orders are basically injunctions which require the removal of one party from the property. Very, very difficult to get. Absent really quite serious domestic violence. And occupation orders here, I suspect, but certainly in England, were an attempt to get away from that system of having ouster orders, which were very, very difficult to get, very messy, evidentially, to prove. So this was the place that this filled, this need for emergency relief while you're fighting over what's going to happen with long-term housing. What they've discovered in England is that actually it's still really difficult to get these. And my understanding from the case of Ellendale is that the same applies in Guernsey. You're only going to get an interim occupation order in exceptional circumstances.
I think we have something called an exclusion order, which is almost akin to an ouster order.
Okay.
That the department can bring to remove something from the house.
Where you are in what we call public law proceedings, and we'll look at that when we come on to talk about kids in a moment, the court can make something called an exclusion order, which stops someone from coming into the home. So it is, it's useful in domestic violence cases. It's not a remedy against domestic violence as such, per se, because it's about keeping children safe. So what they are talking about there is the home is a safe enough environment for the kids, but only if he's not here. So we're going to have that exclusion order. And actually, if you breach it, you're in serious trouble, and that's when kids start being removed quite often. So we'll have a look at that in a moment. But yes, that is an ulterior, that is a different thing, but not something that can be used by a spouse who's getting divorced. It's normally the department, I would imagine, that apply for that. Yeah, it's the minister in Jersey and the local authority in England. So that's a public law remedy where the state is saying you shall not come here, sunshine. Here, these are remedies that spouses can use or partners to try to protect themselves. So the court can make an interim occupation order, and this is at the interim stage. So this is before the court has sorted out the long-term finances. Either party can apply. The court can make it of its own motion, which is quite useful. The court will nearly always try to hear both parties. They really don't like, the same is true of ouster injunctions, or was true of ouster injunctions. They don't like making these orders without hearing both parties, because the effect might be to render someone homeless. And of course, there could be contested facts. So the court can say a particular property is property for the purposes of living accommodation for a child, and can grant exclusive occupation of it. They can put conditions around it, very wide discretion. They can tell someone to leave. They can require them to let the other person come in. They can grant possession of furniture and contents. They can exclude people from a defined area in which the property is located. And that's really the useful bit. Same if you're drafting injunctions. What you want is an order that so-and-so, if they're really dangerous, can't come within a certain distance of the house, because that's actually when you get the chance to do something about it before there is a real problem, so before they're actually on the doorstep. Otherwise, you do get cases where people will stand outside across the road and stare for days in order to intimidate their former partner. What's the court got to look at? Article 43B, the housing needs and resources of the parties and the child. Their financial resources, have they got the money to rehouse themselves? Can they go off and pay rent somewhere else? What the effect of the order is going to be, or a decision not to make the order, on the health and well-being of the parties and any child. It's just my phone. And the conduct of the parties, so how they behaved. Normally they're going to be for a specified period or sometimes until further order. Okay. So these are short-term emergency orders really to try to help people. Okay. So where it comes from, where it's drawn from is section 33 of the Family Law Act of 1996. So you might find some of the English case law worth a look. Certainly if you were applying for an inter-occupation order, I would, if I were you, have a look at some of the English cases, but remember that your law is not as complicated, but the basic principles are the same. So it is different but similar. Quite a useful thing to have. And section 33, as I say, gets a knickers and twist because it has these different categories of people that it applies to. So it's an exceptional order, can be helpful, but only if you're married and you've got children, which of course does not apply to everyone. Then there is what the magistrate can do. The magistrate can give you domestic violence orders, and that's under the DPMCL of 1988. Worth pausing just to think, in England, what they tried to do with the Family Law Act in 1996 was two things. The first is to reform divorce law, which failed miserably. In 1996, the Family Law Act tried to bring in no-fault divorce, and it fell flat on its face and was repealed. And that is the bulk of that law. The bit of that law that has survived relates to domestic violence, generally. And that's because it was around that time that we began to realise how important domestic violence was as a dynamic within families. So the English government said, no, we need to have specific legislation which deals with this, and this is how we're going to do it. And it introduced a raft of different orders, the idea being that rather than have a little order here and a little order there and an injunction there, from different bits of legislation, they would put it all in one place. So under the English Act, you can get your domestic violence order, you can get your interim occupation order, you can get an order in relation to harassment. It was a sort of one-stop shop. It was designed to simplify the law around domestic violence. Here you've got domestic violence orders given out by the magistrate. Understands that there are different sections which apply to people who are married and people who aren't. So this is how the law can give some help to people who are not married, classically cohabitees, and they can do it under the magistrate's law because it's not the matrimonial causes law, so they don't have to be married. But it is dealt with in different sections. You've got section 15, so a domestic violence order stops someone from molesting or threatening a party or a child. Can tell them to leave or not to enter the matrimonial home, can allow the other one to stay there, can order them not to do anything to cause distress to the other person, and not to incite any person to do it on their behalf. That's quite useful because quite often what you'll find is that the messages or the behaviour or the stalking is being done by their best mate or a relative, which is lovely behaviour. Can be made for a particular period of time, can have lots of conditions if it wants to, can be revoked, can be varied. It doesn't affect the ownership of the home, these are not long-term orders. it's again a short-term emergency remedy. And importantly, Section 16, you can have that thing which makes these orders have teeth, a power of arrest. Any form of an injunction in family law cases, down at the bottom of page 89 now, any order which tries to provide protection is really effective only if it's got a power of arrest attached to it, because you need someone who can go and grab them when they start to breach it. You need to get them lifted. Otherwise, it doesn't necessarily help you very much.
If you did have a power of arrest attached, if something did happen, would you just have to bring it back before the court?
It's still a breach, yeah, it's still a breach, but certainly what happens in Jersey, again, it doesn't really make it clear what the procedure is. In Jersey, what would happen is if you breach it and there's a power of arrest, they are lifted immediately by the Viscount police and held in custody until they come to court, if they breach power of arrest.
Okay.
If there's no power of arrest, they can only lift them if there is a criminal justification for doing so. So if there is a real or anticipated breach of the law on a criminal level, then they can detain them. If you've got a power of arrest, they can lift you for being in breach of the order or appearing to be in breach of the order. We have powers of arrest that go with non-removal injunctions, non-molestation injunctions, anything really. They normally last for a specified period of time. In Jersey, it's up to 6 months. And you can get renewed. Okay. Makes more sense. I always thought 6 months is quite a long time.
Isn't it? Yeah. I think it's 3 months.
Yeah.
If it's an interim order, it can't be longer.
It makes sense, and then you can get them renewed. The whole point being, the important thing with domestic violence is that there are hotspots when things are particularly risky. But once those hotspots have gone past, you do want people actually to be able to get on with co-parenting children. You don't want to have a permanent injunction there or a permanent bar to them getting on with their lives, because it does make co-parenting children very difficult. So you want to deal with the emergency without necessarily having a long-term impact on someone's life unless you have to. Because the truth is, most of these cases calm down, they do. And 99.9% of them will calm down. Every now and again they won't, and that's normally because there's a serious mental health issue in play. In other words, they just can't get their head around it for whatever reason. So you can get power of arrest attached to any of the domestic violence orders. And even if you don't have a power of arrest, your magistrate can direct the respondent's arrest if they feel like it, but they're going to need, I would imagine, an affidavit in support. Problem with that is magistrates aren't always around when you need them. I don't know what hours your magistrates work or how many you have. How many magistrates you got? We've got 2. We might have a couple of relief magistrates as well. But yeah, I mean, getting hold of one at a weekend, which is when these things happen, is probably not going to be easy. So section 17 is the bit which says that it can apply, so the same powers can apply to 2 people who live or have lived together as if they were married. Now, I don't think you've got any case law on this. There is some English case law around what that means. So in other words, when are you cohabiting? How do we define cohabiting? I think we might have looked at that in the context of ancillary relief, that case of Kimber, I think it is, where people are actually living together as a couple and when they're not. I don't think you've got... Yeah, you can, you know, does it apply to a brother and sister living together or 2 mates? You know, what is it that gives it the flavour of being a cohabiting couple? As if they were married are probably the key words in there. So this is definitely a provision that is aimed at people who are intimate with each other. It's not a provision aimed at general members of the population.
There doesn't have to be children involved, does there? So it could just be you're in a relationship or something, yeah. As long as you live together.
Or have lived together. Interesting thing though is that do all people who experience domestic violence live together? No. So why have that distinction?
Because then, you know, they've got their own home, they're not living together.
Yeah, it doesn't stop you from being a victim of domestic violence quite often.
How would you, if they were coming to your house and abusing you, how would you keep them out?
I can understand why you wouldn't have a power to permit them to bar the matrimonial home. That would make sense if they're not living together, but not to molest or threaten the applicant. Why would you have to be living together for that to be a thing? I mean, I'm quite sure that normal people who are not a couple, can get non-molestation injunctions here, or non-molestation orders, are probably known. People who are friends who've fallen out or whatever, I'm sure can, but it's interesting that that particular protection is afforded to people who live together. It could be a recognition of the fact that these problems tend to surround the matrimonial home or a home that people share. And that tends to be where they come from. You have a lovely protection from harassment law, 2005. It is a criminal offence. This is partly where the criminal law crosses over, and they can be imprisoned if they are convicted. And it's an offence to put someone in fear of violence. What is harassment? There isn't really, and probably shouldn't be, one definition of harassment, because it is one of those things that you don't want to define too tightly, because you want to be able to, as a judge, have the freedom to deal with a situation that he's dealing with without worrying about whether it falls outside a very posh definition that you've given. So harassment is not a one-off, it is a course of conduct. That's important to remember. You do not harass someone if you do one bad thing. Harassment requires a course of conduct. And that's just a linguistic thing. Includes alarming people or causing them distress. Requires at least 2 occasions of behaviour. Can include speaking, writing, or any other form of communication. Remember those text messages I was talking about, WhatsApp messages, emails. Those are classic examples of these kind of things. Of course, they will have gone out and bought a phone that they can't be identified from before they do it, which is one of the problems. So that's part 1. Part 2 relates to civil proceedings, where you've been convicted of an offence. The court can also make a restraining order. Okay. So another form of injunction almost. And you can ask for damages if there's a breach. So you can actually sue them for damages. And you can get damages for anxiety, although I do wonder how that's calculated. And financial loss. So you can get your normal financial loss, but you can get damages for anxiety. As I say, I'm not sure how that's measured. The time limits. Most forms of tort, as you all know, have a prescription period attached to them. The time limits set out in your Guernsey law, which relates to that stuff, do not apply. So the aim is to, probably in recognition partly, I wonder, of the fact that people tend not to complain about domestic violence quickly and quite often, not while it's actually happening, or not until it's been happening for many years. The court can just give you a normal injunction, normal civil relief, if it feels like it. And if you breach an injunction, you are guilty of what? Contempt of court, which is a pseudo sort of criminal offence, and the court can impose criminal sanctions, including imprisonment or a fine. You may commit a criminal offence and a breach of an injunction at the same time. They won't punish you twice. They can either treat it as a criminal offence or they can treat it as a civil matter. And this is the ordinary court, probably because of the pseudo-criminal sort of nature of this. It's not the family court sitting, this is the ordinary court. And I suspect that these are remedies only given by the Royal Court. You have 2 practice directions you need to know about. Practice direction 5 of 2004 relates to applications for domestic violence orders. Now, this is the kind of thing, if you were going to get a practical exam, perhaps for drafting, this is the kind of thing that would actually test your skills. I'm asking you to draft a divorce petition, a concise statement produced, signed by the applicant or their advocate, setting out the salient facts on which they rely. If the order is granted ex parte, so the other side isn't there, the statement of facts has to be served with the order. In inter partes cases, it's going to be served with all of the other papers. So you're going to need some evidence, a concise statement. Okay. Interesting enough, we were having a chat earlier about Mr. Justice Macfarlane, new president of the Family Division in England, saying that all family lawyers have far too much of a workload and it's really not very fair. One of the things he said was that the documentation required is far too long, and that actually there was nothing wrong with saying that position statements, for example, should be limited to one side of paper, because what you are saying, if it's important enough, you should be able to say concisely. And there is a real drive in family law, a real drive, particularly in England, to say if a judgment's worth doing, it's worth being short. So in other words, judgments should be concise. They should only be a few pages long, because if it's worth saying, you can say it in a few words. The rest of it is just filler. And you should be able to explain the law in clear, unambiguous language that a man in the street can understand. So there is a real drive to get that going and to have conciseness creeping into the room, to take some of the mystery out of it. And that is a skill, to know what to put in one of those statements and what not to put in one of those statements, because you don't want to inflame the situation and make it worse. You don't want to make an allegation that you don't think you've got some credible evidence of, whether it's your client's own testimony or somewhere else, because they are going to be held to what they say in that statement, and they do not want to trip themselves up based on that. So, and it may be done at a very early stage. You may not know them very well when you have to draft that document. Practice direction 6 is the bigger one, longer, and this relates to applications in relation to kids. So if you are applying for a child arrangements order, so an order about where a kid's going to live or who it's going to see, who it's going to have contact with, or if you're looking for an injunction where there is a child floating about, you must follow this practice direction where you know there is domestic violence, or where you suspect there is domestic violence, or where someone is alleging domestic violence. Okay, it may be you've got a conviction which tells you that there's violence there. It may be that it's suspected, or it may be that it is alleged. Okay, and this is to make sure that the judge at the very beginning of these cases knows what the landscape is, because the judge is going to have to think about whether to make interim orders. In some domestic violence cases, the judge is going to think, do I need to make an interim residence order at this stage? Because sometimes that can bring some safety with it, particularly where you're worried about child abduction or something like that. Okay, they'll think about whether there should be interim contact or not, and whether that contact should be what we call supervised, which means there's another adult there. Supervised contact normally implies a professional trained adult. Okay, and the court can only think about this stuff if it knows there's a problem. It's worth having a look at the domestic violence practice directions in play in England, which are similar and which change from time to time. They're reviewed quite regularly. Okay. Now, when I was saying earlier that we have lots of different explanations and definitions of domestic violence, the practice direction has its own definition of domestic abuse. Physical violence, extreme or excessive threatening, insulting or intimidating behaviour, and any other form of abuse, which may have caused harm to the other party or the child, or which gives rise to risk of harm. Harm means ill treatment, the impairment of health and development, including impairment suffered from being present in the same premises or witnessing or being aware of the ill treatment of another, And again, that has come out of what we now know about the impact of domestic abuse on kids. Because we know that if you see and experience someone you love being treated in this fashion, that has a traumatic impact on the child and undermines their trust in humanity almost. It's really quite profound. Okay. Unfortunately, again, I would say that isn't very accessible language. And all of this stuff is quite complicated, which is why in England, domestic violence is one of the few things that entitles you to legal aid on separation of divorce. Very little private law is funded now in England for family matters through legal aid. You're expected to do it yourself or pay for it. Domestic violence is the exception to that because of the tricks and traps that are there. Court has obligations. It must, at all stages of the proceedings, consider whether domestic abuse has been raised, and if it has, identify the factual and welfare issues involved. Let's look at the nature of an allegation and whether, if proved, it would be relevant. It's got to give directions to enable factual issues to be dealt with. If you need to have a trial to find out whether a fact that is alleged is true, have it as soon as you can. Don't delay, because otherwise cases can stretch out for years. The court's got to think about whether to alert the Children's Service to a problem. The judge has the same problem you guys do if they think there's a risk to a child. But they have to ring the Children's Service and say, I'm worried about this family. Any agreement that is reached is scrutinised by the court, and they may want to report from the Safeguarder Service or whatever it's called these days. Okay, that's because quite often what you will get in a domestic violence case is they'll reach an agreement. A shared care agreement is quite common because the party who's being abused will back down quite quickly, quite often, and will say, okay, you can have them half the time. A court must only give that order its blessing if they're happy it's in the best interest of the child. And if they don't know there's domestic violence, they won't know there's an issue. So the court's got to look at that very carefully. It sets out actually even the procedure for a fact-find hearing if there has to have one, which is great. And it requires continuity of judging. In a domestic violence case, it's very important that you don't jump from judge to judge to judge, so that whoever you are in front of knows the background to the case. A, so you don't have to go over it a million times, but also B, because domestic violence cases require helicopter vision. They require people to understand the whole dynamic of the relationship in the case. If you've got 6 judges dipping in and out of a case, that isn't going to happen. So it's very important you have judicial continuity when you're making decisions. And this was actually done before, I think, you got your, just before your children all came to effect, which wasn't until 2010, I think. Yeah, January 2010, your children all came to force. So they wrote this practice direction, envisaging that it would remain in place once that law came in. So it's still, we know it's still effective. So we've got activity 1 I have given you there. Okay, let's have a read of that and then have a chat about it. And then perhaps we'll take a break for lunch so that Siki there can have a rest. Make sure you get something to eat. So have a read of it and then we'll have a chat about how you think you would advise Barbara. And as I say, this is a very classic situation.
Barbara's a terribly unlucky woman.
Well, subject to emotional abuse. At least.
Yeah.
Physical.
Do you find that you do get cases that have everything in them, though?
Yeah.
You do have cases where you seem to have the unluckiest client in the universe. And they're always the difficult files that you dread, the ones that sit on the end of your desk and never move, because you know that something's going to happen. Normally at 3 o'clock on a Friday.
Friday afternoon.
Yep, always. So it's Friday, 11 o'clock in the morning. You've been advising Barbara for some time, but she finally admits there was some domestic violence in her marriage. He was very controlling. She has little contact now with family and friends. Adam has told her that she's mad and that she's going to lose care of the children if he reports her. Again, that's a classic one. She's terrified that this might be true, and they really will be terrified. They'll ask you for guarantees. Can you guarantee that the kids won't be taken away from you? And of course, you can never give that guarantee. On 3 occasions, he's hit her. On 1 occasion, he put his hands around her throat, causing harm. But she says he was stressed out and that she had been annoyed him. She'd been annoying him at the time. He's a gentle person. They always are when they're not being violent, and has always been very sorry. He drinks a bit too much, and she's learned to leave him alone when he is drunk. So you've got another issue there, and they quite often crop up together. In fact, there are 3 issues that very often crop up together: drink or drug abuse, mental health, and domestic violence. They're called the toxic triad because you quite often see them in a lot of children's cases, all 3 at the same time. They feed off each other. A lot of domestic violence is linked to drink. Barbara's a bit nervous, air quotes required, that Adam is coming to the house on Saturday, which is tomorrow. Hopefully she's giving me lots of notice. He's texted her to say he wants to talk to her about money. Her horrible lawyer has some strange ideas and he wants to set her straight. Barbara doesn't think he's going to hurt her, but she plans to make sure that the children are in the same room with them at all times, as that is likely to keep Adam in check. He'll probably just swear, shout and scream, and the children are used to that. They will take it in their stride. So what kind of things do you think you'd be discussing with Barbara, who is very much a real client? These are the kind of things we see. I do anyway.
If you just take it in turn and go through the different types of harm that she is actually suffering from, this might not realise. So if they're cutting off from friends or family, there's emotional harm, although it's very difficult to prove that one, isn't it? But then when he says that he loses care of the children, he reported her, I don't know if that would come into a bullying scenario. To say, she obviously believes it, so is your evidence of harm that it's not just words in that sense? And then you've got physical harm or harassment with the hitting of the throat, around the throat.
How about if Barbara specifically is one of those people who would like to get divorced, but previously you've not been quite sure that the ground was made out, or that the fact was that a fact was there? Would this cause you to give her some advice around divorce?
Well, potentially, if she wasn't going on a behaviour petition, then you've got it made out.
Yeah.
As long as you could say when about to happen.
You'd want to know a bit more, wouldn't you, about when this violence took place? Is it recent? Were there?
And that's all.
Was it all close together? Has it all been spread out over 10 years, or are these incidents quite close together?
Yeah.
The one that's probably really going to worry you is there's 2 issues here. There's what use you can make of it, or what you have to bear in mind from a litigation point of view. And there is protecting your client. So from a litigation point of view, you'd be thinking, oh, well, if I've been looking for grounds for a divorce or a ground for a divorce, actually I've now got it. that may feed into protecting your client, because that may cause a safety problem if you issue proceedings. But you might be thinking, yes, I need to bear that in mind. You'd be thinking, well, if I'm sorting out the money, I need to be aware of this dynamic, because he's very controlling with money. So that's going to be relevant to dealing with the finances. You're going to be thinking about whether you need to be taking any steps, probably to keep her safe. And you're going to be thinking to yourself, well, if there are issues around the children, I've got to remember that practice direction is there. I've got to remember that if this is a case where there are issues around children, I'm going to have to be making sure I comply with that practice direction so the court is informed. Part of looking at whether you need to consider interim occupation order, it would seem that they're not living together at the same property anyway. Do you think you might need some other form of order?
So that maybe you could do it under the restraining order and the protection and harassment.
Possibly, or a domestic violence order from the magistrate, I would guess, if you feel it's necessary. What's the incident that would cause you most worry, probably?
The fact that the kids are used to just swearing, shouting and screaming.
That suggests to me you're going to have a heart-to-heart with your client about the effect of domestic abuse on children. Your client needs some information about that, and probably needs signposting to places she can get advice about the impact of this kind of dynamic on children, and you probably want to get a feeling for how affected they may have been, because she seems to be oblivious to it. If they are truly taking this in their stride, then they've suffered harm already. Because if it's when they start to normalise this behaviour, when children stop flinching, when they're shouting and screaming going on, then you've got a problem. Because it's then become their world.
And that's how you could prove that there is harm already.
I think you'd be certainly suspicious there is harm. You can't prove it without having objective evidence of it, but certainly she needs to understand what the impact of domestic violence is on children and domestic abuse on children. Think about, as I say, what you're going to have to tell the court if there are children proceedings. There may not be any here. The domestic violence incident which would cause me to worry about her safety is the one where he placed his hands around her throat, causing bruising. That is a real flag of serious domestic violence, which could lead to death. Strangulation is a particular flag for me. And you've been saying some stuff which has upset him. So you're going to have to assess whether actually there is a risk of something nasty happening here. And she's going to have to be told to ring the police if she needs to ring the police. No matter what orders you set about obtaining for her. So you can probably see from that chat there that what we've done is it's affecting every area of this case. There are particular domestic violence remedies you're going to have to think about. Am I going to apply for any of these? And if so, what's available to me? And do we need them? And you have to remember your obligation to the court under the practice direction. And you might signpost her to services, might you not?
Would you, the fact that she says does not think he would hurt her, but just in case, is that maybe evidence that she is more concerned than you know?
I think there are two things about that worry me. It's doesn't think he would hurt her, but he has tried to strangle her before, potentially, which would suggest to me that she's normalising violence. But you know, she's perhaps not really thinking about the risk that she is being subjected to.
It looks like it's a pattern of behaviour as well. It's in the same way.
Yeah, that would really worry me, and I've seen women do it. And it's making sure she understands that her children are not a human shield. which is what they're being used as here, it is not good parenting. At its mildest, it's not good parenting. And the Children's Service would be horrified. I hope.
Whether you would go through the possible options, you could discount the occupation order because it doesn't seem that he lives there at the moment.
It doesn't sound like it, does it? Because he's coming round to the house tomorrow. That doesn't necessarily mean you wouldn't need an order stopping him from approaching her home. It would suggest that from an interim occupation order point of view, he's probably not living, they're probably not fighting over who's living in the house and who's leaving.
So maybe it would be a contact in the realm of the family home situation?
It may be I don't want you coming within X of the family home, although she doesn't seem to want to stop him from coming within the family home. It's maybe a case where you've got a client who's reluctant to apply for any of the orders that you are recommending that she think of. She may not, she's most likely to say, but I want the kids to have a good relationship with them. Is quite often what they will say. But at the end of the day, it's up to her to at least a degree. You're going to have to assess whether you are so worried about these children you need to ring someone, aren't you?
Or if it talks to a senior partner, is the answer.
Well, phone a friend is often a good answer in these situations, in terms of getting advice from someone on what they think your professional obligations are. But you would certainly want to explore with her parenting why she thinks that that's a good idea, so that she understands the risk to the children of doing it. And perhaps suggest to her that perhaps it would be better if she wants to meet him that she met him in a public place when the children are not there. If she wants to have this discussion. It is a judgment call, which is partly why it's so difficult. It may be, for example, that the occasion when he placed his hands around her throat was 5 years ago. And he's since had an extensive course of counselling. You know, you'd need to gather a bit more information, I think, about it in order to advise her.
And if that were the case, then so it was 5 years ago. Had some counselling, just discounting.
I don't think you would discount it, but it might affect, you know, I think you would say to her that legally these are your options. What we do comes down to how scared you are, or whether you are scared. But I think this is very unfortunate that this happened. We should be thinking about how we keep you safe. Because he's clearly upset with me, being the lawyer. Things are not going to get easier. Let's think about how we keep you safe, because using the children is not a safety strategy. So we need to think of something else that keeps you safe.
You also, about the lawyer, when you've got advocates instructed, communication is supposed to go through them, isn't it, not between parties? Maybe just
when you write a letter, who is the ultimate audience for the letter?
Yeah.
Do you ever get, or how often do you get a substantive letter from the other side you then copy to your client? And lawyers forget that. That's one of the really important things about the tone that we use with each other. If you send an obnoxious, stroppy letter to a lawyer on the other side, you're not just talking to the lawyer. You're talking to the client underlying the lawyer, because they will see it and read it, and they will be furious. And they will take it out on the other half, almost always. You'll get emails saying, I've just read your lawyer's letter. How dare you say that about me? Because I don't see it as being a letter from the lawyer either. I see it as being a letter from their other half. Always. So it causes tremendous upset and explosions. Having said that, whatever you were going to do probably would have upset a man like that.
So what orders would you be going for?
I think it's a matter of, at the end of the day, you have to take instructions, don't you? So at the end of the day, it's a matter of saying to your client, well, these are the kind of orders that are within the court's jurisdiction in these circumstances. This is the toolkit a judge would have. these are the orders I think we can apply for on the evidence that we have. Whether you want to apply for one of these orders really comes down to whether we feel they are necessary and appropriate. Bearing in mind that they do up the ante. They are by their nature inflammatory themselves. They don't always make life better. They really don't. Injunctions quite often make things a lot worse. So it is a bit of a judgment call. So you explain to them what they can do, discuss with them what you feel they should do, and that comes down to partly how much of a risk there really is, you know, on their judgment and yours. And then you take instructions as to what they want to do. If they instruct you they wish to do nothing, then you have to think, do I have a professional obligation to alert someone to what I think is at risk? A personal injury. Or her.
What do you think in this case?
I'd form a judgment call from talking to her. I think the most you could say on this scenario is I would think about whether I had a professional obligation to notify someone if I felt that the children were at risk.
The children in this scenario, you're more concerned.
I'd probably be more worried about the kids than about her, but I would be worried about her.
Unless the last time came around, and that's when you put hands on her throat. That would if the incident with the strangulation had happened a week ago and she hadn't reported it to anyone, I'd be very worried. I'd be very worried about that, and I'd be wanting to do something about that, I suspect. And you'd want to have a discussion with her around what is okay and what is not okay in relation to the kids, and what her keeping safe strategies are, because I'd be saying to her, it is not appropriate for the children to have this role. And I'd probably give that clear advice, this is not okay. You cannot do this, cease and desist, let's have another plan. And that may lead into a discussion about what orders you can apply for, actually, and how you signpost different things. It may be that if there is no risk, him having contact with the kids, it's probably not a good idea to mix contact sessions with arguments about money or discussions about divorce or anything else. If you're seeing the children and everyone's happy, it's safe, fine. But having an argument around money when he turns up to pick up the kids is not a good plan. Contact should be a separate and special time for the kids. And you'd want her to be thinking about whether she feels the children are safe with her. But those are things that you need to discuss with her, set out what her options are, take instructions from her, and then once you've got those instructions, you decide whether your professional obligations drive you to do something different. And it's quite often at that point you get sacked, if they disagree with you. Can you promise me you won't tell the judge this? No, I can't. You're going to see someone else then? All right. If you tell them what you've told me, they're like to say the same thing. Yeah. And then they don't tell them, which is. I think you always have to think about, I mean, professional obligations, you know, we have a code of conduct, we have a code of ethics that we must fulfill. But a lot of it is about being a good citizen, isn't it? If you think about it. If someone came to me with this scenario and... no, if I was not the lawyer, if Barb was a friend, if she came around, had a cup of tea and said, look, this is what was going on, I would probably call the police. And oddly enough, I might even do it quicker than I would if I was acting for her. Because if you're acting for her, you've got to follow through with these illegal options, that this is what we can do, these are the people who can help, the police are there, this is my advice around parenting children in these circumstances. Now, what should we do? Give me your instructions, client. If this was a friend, you don't go through that process, you just think, am I concerned for her welfare? Do I need to at least alert the police so they can keep an eye on them? But that is a very personal line. There is no requirement on you as a citizen to do that.
No, not even with the kids.
There's no requirement on you to, there's no good neighbour requirement out there in the world. People like the Children's Service rely on it. They rely on people ringing when they're worried about kids, because a lot of child abuse social workers would never be aware of if it wasn't for concerned people ringing them, because they have no way of knowing what goes on behind closed doors a lot of the time, unless it's happening in school, or there's evidence of it in school, or it's neighbours calling the police, neighbours ringing the Children's Service anonymously, whatever. They rely on that information. But different people have that line in different places, and there's certainly no law around it. Whereas your professional ethics are your professional ethics, and even then, different lawyers would draw that line in different places. This is the truth of it. Which is why it's never a bad idea to give your senior partner a ring if you're not sure what to do. Someone you trust, your pupil master, while they're there. It's when you are the senior partner you have a real problem. And people are saying, oh, what shall I do? Oh, God, I don't know. And so it's easy. Right, so we've done that. It's 12:30. What would you like to do? Would you like me to start with an outline of the children's law and where it comes from and what it aims to do, and then we can have lunch about 1 o'clock and take a proper break, and then have a break sort of mid-afternoon or something like that, or would you rather stop now?
We'll have 5 minutes.
Of course.
And then come back.
Yeah. Just to set the scene, really.
Yeah.
Just to get your sort of brain working about kids, and then we'll come back and start it properly. Yeah, so let's take 5 minutes to go to the loo or have a cup of coffee or something.